Hi, I'm Danie Mellas, Senior Associate at Nichols Family Lawyers, a boutique specialist firm with offices in both Melbourne and Geelong. A common misconception we see in family law matters is the belief that an inheritance is automatically protected when a relationship breaks down. Many people assume that when it comes to finalising a property settlement, the person who receives the inheritance will simply get it back in full, or at least retain whatever is remaining. In reality, that's often not the case. Inheritances received during a relationship or marriage, and even after separation, can impact the asset pool available for division between the parties. When dealing with an inheritance, a court applies the same four-step approach that they would ordinarily use in court proceedings and for all property settlements. It involves first identifying and valuing all the parties' assets and liabilities and financial resources at the time of the hearing. The court then considers the contributions made by each of the parties. Next, the court looks at whether an adjustment should be made in account of the parties' future needs. Then the court will decide what is a just and equitable outcome for each of the parties, whether an inheritance is included, and the weight it is given. It is assessed on a case-by-case basis. The court will consider the following range of factors: when the inheritance was received or is expected to be received, the size of the inheritance compared to the overall net asset pool, whether there is an expectation of an inheritance and how the parties may have factored that in, and whether the parties have contributed to the inheritance, for example, by way of providing care to that person whose estate forms part of these proceedings. Generally, the court does not consider expected inheritances or any sort of future inheritances that a party may assume that the other party may receive. Inheritances are particularly common in separations later in life, where one or both parties may have received funds following the death of a parent or a family member. Inheritances can also have implications for spousal maintenance. Spousal maintenance is a form of financial support that may be payable where one party has demonstrated a need, meaning they cannot meet their reasonable living expenses from their own income or assets. The other party may have the capacity to provide support to that other party. For example, a person receiving spousal maintenance may lose their entitlement if they receive an inheritance that enables them to financially support themselves. A person who receives an inheritance may become liable to pay spousal maintenance if their former partner has a need and the inheritance is sufficient to meet that need. This is why, moving forward, it is important that asset protection tools are used, such as binding financial agreements, which can play a critical role in setting out how inheritances are to be treated and providing greater certainty should a relationship or marriage come to an end. A binding financial agreement, often referred to as a prenup, or as others refer to it as a BFA, is a legally binding document entered into by the parties outside of court proceedings. These agreements allow the parties to contract out of the general provisions of the Family Law Act in relation to property and financial matters, effectively enabling certain assets, such as inheritances, to be quarantined from the asset pool available for division. This prevents the other party from making a claim against any inheritance received by the other party in either the past or the future. A binding financial agreement can be entered into at various stages of a relationship or marriage. Some couples choose to formalise an agreement before marriage, or at the commencement of a de facto relationship, while others may do so during the relationship or marriage, and at times can be entered into after separation and divorce. It's important to note that strict legal requirements apply to the preparation and execution of a binding financial agreement for it to be legally enforceable. If you require legal advice in relation to an inheritance or a binding financial agreement, please don't hesitate to get in touch with our office. Our team has extensive experience advising on inheritances and preparing financial agreements tailored to our clients' individual circumstances.